SMU constitutional law professor Dale Carpenter, thank you so much for joining us. What do you make of the lawsuit filed today by Texas and the Texas Attorney General Ken Paxton against these four battleground states?
Well, this isn't so much a legal filing or legal document as it appears to be a political document. It really stands very little, if any, chance of succeeding in the Supreme Court, but it may signal support for President Trump and signal support for those who wanted President Trump to win the election.
So why do you think that the Supreme Court is really not going to hear this case?
Well, there are a number of problems with the complaint that was filed by the state attorney general today. One of them is that Texas may not even have standing to make this challenge. It isn't the right party to challenge results in other states in their presidential election contests. That's a real problem for Texas. It's also the case that Texas waited a very long time to file this complaint. The election procedures that Texas is concerned about occurred over the last summer and the last few weeks before the election. The voting began, the counting began on November the 3rd. Election results were certified in November and early December, and it's only now, the day before these states can choose their electors safely, that the state has filed this challenge. That is going to be considered untimely in the Supreme Court. Texas should not have waited so long.
Well, when should it have filed if they were going to even do this?
Well, it possibly could have filed when the election results were coming in and the counts were coming in and there were complaints about the way the ballots were going to be counted, or at the very latest, when the individual states were certifying those election results, and that was weeks ago in some cases.
So let me ask you about what you said as far as whether Texas has standing. The fact that this involves the Electoral College and that this is a national election, do Texas and all these other states have say in the sense that what happens in one state impacts, all states, or no?
Yeah, so Texas has to have, to show that it has standing, Texas has to show that it has a particular stake in the outcome of the internal election of another state. And it has to show that it has a kind of particularized standing, that it has been hurt in an especially great way. And it really can't show that any more than 320 million other Americans can show that, or than the other 30 million Texans could show that. It's not the kind of standing that you would see in, say, a lawsuit where someone was injured in a car accident, where a bystander said that they were hurt because they saw the accident, but it's really the people who were injured in the accident that were actually hurt, and those should be the ones bringing the complaints.
In the actual body of the lawsuit, the Texas Attorney General mentions the electors clause, equal protection, and due process. For the electors clause, they say changes made by these other states, these battleground states, before the election, obviously, violated the Constitution because it wasn't the state legislatures that made the changes. It was the states that made the changes, if I read it properly. Is that a legitimate constitutional issue, or just not by this particular lawsuit?
I would say it's not legitimate under this particular lawsuit, and let me explain why. The state attorney general, Ken Paxton, is essentially trying to litigate or relitigate claims that are being heard in various other lawsuits and that have already been heard to some extent and can be heard in the Supreme Court. So the Supreme Court doesn't need to hear this from the state of Texas. The second thing I would say is that state election laws quite commonly grant full discretionary authority to state election commissions to make changes as needed certainly under the kind of circumstances we've seen in the last few months, to allow for more voting and more voting that's more amenable to the citizens of the state under these conditions. So it's not the kind of thing that's just being changed willy-nilly by a state governor or by a state election official. So there's a real question there. And then third, there's a question about what can be allowed, a legal question about what can be allowed under a state's own election system under the Constitution. Those are open questions, but they don't need to be raised by Texas. Texas doesn't bring anything special to the table.
So, in other words, that goes back to the standing question?
Goes back to standing, and it also goes back to the fact that these issues are, in one way or another, being already litigated in lower courts and in the Supreme Court.
And what about, so I know, for example, in Pennsylvania, where you and I have discussed, constitutional issues really right after the election, there was a member of Congress there, a Republican member of Congress, who's filed suit, and the U.S. Supreme Court is going to have to decide whether it takes that case on. That is a case where they would have standing, obviously, because it's somebody in that state and somebody directly impacted by it, right?
Yes, I think someone like that could probably bring a lawsuit in the Supreme Court and be heard in the Supreme Court. But the Supreme Court probably is not going to want to get involved in an intensely, I would say, difficult constitutional question unless it's going to make some difference in the outcome. And even in that case, there's no indication that a difference would be made in the outcome in Pennsylvania, where the margin is something like 80,000 votes at this point, and the results have been certified. So even there, I doubt the Supreme Court is going to get involved, but it's possible they could get involved. And here, at least that purely legal dispute, it wouldn't change the outcome of the election in any way, or even the election in Pennsylvania. But to hear the Texas complaint, it's just basically the Attorney General is kind of grandstanding.
And just on that thought that you had before with regards to the Supreme Court making a decision whether it's going to accept a case or not, based in part on that it doesn't change the outcome of the election. And I know you and I have discussed this before. At some point, though, because of all these legal questions over whether the U.S. Constitution was violated or not, and I know and I hear your argument that it really depends on the state's constitution, whether they grant other people outside the legislature the authority to make changes as they see fit. But at some point, doesn't the Supreme Court need to step in to kind of establish firm rules so that people all across the country know what they are, instead of having all these questions being raised all the time in future elections?
Yes, there is. There's a tension on the court between reaching out and deciding issues that before they have to be decided, and therefore giving clarity to everyone. And on the other hand, reaching out and deciding issues that they don't need to decide, and using up some of their authority to be able to make those decisions. So there's a balance there, and the Supreme Court may decide that it is going to try to resolve some of the legal disputes in this election context so that we can have more guidance in the future, although I still think that's probably not going to happen. And again, it's not going to happen in a way that's going to change the outcome of the election.
Several more questions. Wanted to just ask you your thoughts on the equal protection and due process claims put forth in this lawsuit. Again, does this just go back to standing and the lower courts in other states, considering this?
Yeah, so the standing issue is what we call a threshold legal issue. Before you even hear the merits of the claims, does the party that's asserting the claim have the ability to bring those particular claims? The merits claims are the claims that you mentioned earlier, like the constitutional claims, were the issues, were the election procedures proper under the state legislature's rules? Could they be constitutionally considered? The equal protection issue and the due process issue. The equal protection issue is in theory the kind of issue you could bring in the Supreme Court, and indeed it was a concern in Bush versus Gore, where the problem was that the Florida recount was proceeding under a vote counting procedures that just didn't give people equal voting weight, that the Florida Supreme Court was allowing votes to be counted differently in different parts of the state, and that didn't seem fair. But the Supreme Court limited that decision to the one single circumstance of Florida and did not extend it beyond that to consider other election equal protection challenges in the context of an election. So there's no reason to believe that that's going to be any precedent in the future. In theory, it could be, but we don't have any evidence yet that that's the kind of violation we're seeing in the states. And so again, part of the problem with the state attorney general's argument is not just that there might be a veneer of a legal claim here, but it also involves intensely factual disputes that have been resolved in other litigation, or that are being resolved in other litigation, or that have been debunked and discredited by federal and by state authorities. So there's no real equal protection or fundamental due process right involved here that we know of. And again, as you and I have discussed before, the Supreme Court is not going to decide in the next few days, apparently, the intensely factual questions about whether there was fraud, or whether the signatures matched on the ballots and in the voting application and all the rest. Those are just not issues the Supreme Court is going to decide.
Right. You always have said to me that it's really just legal questions that go back towards the Constitution.
That's right. Because the Supreme Court doesn't have the competence and it doesn't have the capacity to decide these incredibly, intensely complex and disputed factual questions. It's not a glorified trial court sitting in Washington, D.C. in a marble setting.
Let me ask you, pardon my ignorance, when you talk about the safe harbor, I know on Monday the electors in Texas will gather at the state capitol. So is that outside the safe harbor?
So the safe harbor is a federal statute, a deadline set by federal statute that allows states to choose their slate of electors by a certain date. That date happens to be today. The state attorney general, Ken Paxton, filed his lawsuit yesterday, basically saying that in those 4 states, there could be no certification unless the state legislature got involved. The safe harbor allows the states to be able to choose their electors by today, and do so without having any challenge to that slate of electors in the Electoral College meeting on Monday or in the vote counting in Congress in early January. The problem with the safe harbor is that if a state does not choose its electors by today, then there could be a potential challenge to the validity of those electors in January when it comes time to actually choose the president. So what the state attorney general is asking for in this case, what Ken Paxton is asking for is extraordinary. He is asking basically for the Supreme Court to extend the Electoral College deadline, which it has never done in the history of this country, even did not do so in the election of 2000 that was decided by 537 votes in one state, not by hundreds of thousands of votes across multiple states. He's asking for that, and then he's asking for something even more extraordinary. Ken Paxton is asking that Republican state legislatures in 4 states be allowed to displace the will of the voters in those states and choose their own slate of electors, presumably to hand the election to Donald Trump in January. The Supreme Court is not going to allow that to happen.
In either case.
In either case.
So just very unrealistic.
Very unrealistic.
A non-starter.
That's right.
And wanted to ask you just one other question, and that was I've read comments on social media since this lawsuit was filed, or since it was announced this morning, and some people are saying this is, as you said, it's political, but what some people have said is that this is a case in which the attorney general, who is reportedly under investigation by the FBI, is just seeking a presidential pardon. What can the president, if he chooses to pardon Ken Paxton? He hasn't been charged with any federal crime yet, but his presidential pardon only is for federal crimes, not state crimes, which he is still facing 3 indictments in the state of Texas.
The president could conceivably, hypothetically, pardon Ken Paxton for federal crimes, even if those crimes have not yet been charged. And so, even if he's not yet been indicted, much less found to be guilty, the president cannot pardon either himself or Ken Paxton from state crimes. Those the president has no authority over.
Right. So in this case, certainly he could, if he decides to do that, he could do that only as it relates to any federal issue that Attorney General Ken Paxton may be facing.
That's right.
All right. Well, very good. SMU constitutional law professor Dale Carpenter, thank you so much for your time and your insight today. We appreciate it.
My pleasure.
All right. You take care.
Bye-bye.